Company law. We are going to answer question 2. Company law is a paper at intermediate level. The students have interviewed about the intermediate level subjects. Majority of them told me company law is the easiest. It is the easiest paper according to most candidates. But be that as it may, we will revise it. Hope you are ready to engage. The first part of the question reads, highlight 6 legal effects of the articles of association of a company, 6 marks. B, identify 7 reasons why a company will effect a corporate restructuring, 7 marks. C, outline the procedure for removal of a company director from office, 7 marks. We will first answer part A, and I'm first going to give you a chance to provide the answers. Highlight 6 legal effects of the articles of association of a company. Without looking at your notes, just referring to your memory, give me the 6 legal effects of the articles of association. Claudette. Legal effects of articles of association of a company. 6. Everyone drop the 6 legal effects. Who is going first? Zainab says contractual effect. K says a contract between members and the company. Zainab says company structure and governance. Ishmael says constitution of the company. Zainab says governing internal management. Jepchumba says notice to public. Zainab says regulating company capital. K says designates the powers of directors. Someone says notice to public. Someone says a contract between members and the company. The one who says that is you are defining articles. It is a contract. So you may have a point. Someone says contractual effect. That is true. So one legal consequence, just to use this word contractual, is we can say contractual relationship. The articles of association creates a binding contract between the company and its members. Contractual relationship. That is one effect, legal effect of articles of association. Articles of association creates a binding relationship between, number one, the company and its members who are shareholders, because we know that a company is a person which is separate from the members. By now you understand that the company is a distinct person, separate from those who form it. So an article of association creates a binding relationship, first of all, between the company, which is a person, and the members who are the shareholders. That is just part of it. Then the other part is that it creates a binding relationship between the members themselves. Between the members themselves. So this contract governs their rights, their duties, their responsibilities, procedures, and all that. So do you understand? So it's a contractual relationship which is twofold. One between the company and its members, and between the members themselves. So that is one consequence of coming up with an article of association of a company. You understand? Number two, the second legal effect. The second legal effect is what we call, and what someone, let me check if someone had mentioned it. Let me check if someone mentioned something about governance. Zainab says governing internal management. Yes, internal governance. Internal governance. How do we explain internal governance as a legal effect? Now, candidates, the articles establish the internal rules and procedures for managing the company. Internal governance, managing the company. The rules outline matters like appointment of directors, how directors to be appointed. We may have things like conduct of company meetings, how the meetings are to be conducted. We have issuance and even transfer of shares, how shares are to be issued and transferred. We may have rules in relation to distribution of dividends and so on. Internal governance. That is the second legal effect of articles of association. 3, statutory compliance. Another legal effect is in relation to statutory compliance. The articles must comply with the provisions of the Companies Act. They must comply with the provisions of the Companies Act. That is to say that the articles cannot contain anything that contrasts the law or contrasts public policy. Statutory compliance. We may also have alteration of rights. Alteration of rights. The articles define the rights attached to different classes of shares. The articles, and I think we mentioned that in question number 1. You recall in question number 1, yes, part C yesterday, we discussed about the 7 rules governing the alteration of company status in, and we made mention of one of the rules being articles of association. So the articles define the rights attached to different classes of shares. And a similar question is asked in the same question. I think question number 5. Question number 5 reads, analyze the situation. There is a case, something like a case here. Then candidates were to analyze the situation and advise the board of this company on the legal framework regarding variation of class rights. So there are many questions on shares. Question 1, okay, the answers. Legal framework regarding variation of class rights. This is the alteration of class rights, the changing of class rights. So one legal effect of articles of association is in relation to alteration of rights, and these rights could be any alteration of the rights which generally may require special resolution and even adherence to the procedure laid out in the articles of association. Do you understand? Alteration of rights is a legal effect of articles of association. The articles define the rights attached to different classes of shares, and any alteration of such rights generally require a special resolution and adherence to procedure that is laid out in the articles of association. Five, external relationships. There's another effect in relation to external relationships. Now, while primarily an internal document, like the articles of association, okay, while it is basically an internal document, primarily an article of association is an internal document. While primarily an internal document, the articles can also impact the company's external relationships. It can. And how can it do so? Because candidates, third parties dealing with the company are deemed to have constructive notice of the contents of articles of association. If you are dealing with a company, candidates, the articles of association may affect your relationship with the company. Do you understand? And there are many instances. I don't want to go into instances where it's important for a third party to understand, to know the contents of the articles of association. Because while it is an internal document, third parties may be affected by the contents of the articles of association. It can impact a company's external relationships. Do you understand? Then the points are not coming. Someone says constitution of the company. Ishmael, you are right. Articles of association is part of the constitution of the company. Okay? But we are discussing the legal effects. Another legal effect is in relation to enforcement. Enforcement. Now, in the event of any breach of the articles, affected parties like the shareholders or even the company itself can seek remedies through the courts. And remedies may include things like injunctions to prevent further breaches, or even damages for losses suffered. It could include rectification of the company's register and so on. Like in question number 5, just allow me to digress a bit. Question 5C reads, Pata Company Limited is a company with both ordinary shares and preference shares issued to its members. The ordinary shares carry voting rights, whereas the preference shares do not. The company has been performing well, and the board of directors proposes a variation of class rights, intending to grant voting rights to the preference shareholders. However, this proposed variation is met with resistance from some of the ordinary shareholders who fear dilution of their voting power. Do you see that problem, candidates? The board of directors in this case is, I'm giving an example of what I'm explaining here on enforcement. Let me just use this one. The board of directors in this case are planning to do what? The board of directors are proposing a variation of class rights, and the purpose is to grant voting rights to preference shareholders. Ordinarily, we know that preference shareholders do not have voting rights, but this company wants to change that. And that may be in violation of articles of association of this company. If this decision is materializes, if the board of directors goes ahead and grants the preference shareholders the voting rights, then you can see there is already a conflict, because we read that the ordinary shareholders are against that decision. There is resistance. We read that this proposed variation is met with resistance. So if the board of directors goes ahead and grants voting rights to these preference shareholders, the ordinary shareholders can seek redress in a court of law, because that would be in breach of articles. And I've said that any affected parties in any breach, in the event of breach of the articles, affected parties, which may include the shareholders, can seek remedies through the courts. And that is a legal effect of articles of association, enforcement. And one such remedy could be rectification of the company's register. It could be to rescind such a decision that this board of directors are proposing, or to prevent further breaches, injunctions to prevent further breaches. Do you understand? Have you understood? These are six legal effects. 1, 2, 3, 4, 5, 6. 1, 2, 3, 4, 5, 6. Is that clear? Can I proceed? Yes. I'll give you an opportunity to answer it first. Part 2. Identify 7 reasons why a company will effect a corporate restructuring. Reasons why a company may do what? Reasons why a company may effect corporate restructuring. 7 reasons. B. Reasons why a company may effect corporate restructuring. 7 reasons. Chepchumba says if the company is having financial difficulties. Ishmael says to minimize cost of running the company. Ishmael says minimize cost of running the company. Raquel says to alleviate the possibility of liquidation. Bernard Laget says to minimize the costs. Merger or acquisition was effected. Merger and acquisition. Correct. Merger is a point. To be more efficient. That is a point, Ishmael. Zainab says to respond to market changes. Okwera says to reassess its capital structure. Via debt restructuring. Ishmael says to adopt new policy. Zainab says to adapt new regulations and be compliant. Strong point there. Enhance productivity and reduce costs. Godfrey says enhance productivity and reduce costs. That's a good point. To increase quality of products. To transition to a new mode of operation. Adapt new technologies in the market. Initially, Maureen says if the company is having financial difficulties. Yes. One obvious reason, as Maureen says, is if the company is having financial difficulties. Just to put it in 2 words, Maureen, we can say financial distress. Financial distress can be a reason for corporate restructuring. companies facing financial difficulties such as high debt levels, declining profits, potential insolvency, they may restructure to improve their financial position, because that might involve debt restructuring, asset sales, and even bankruptcy reorganization. So that is true. Financial distress. Someone mentioned mergers and acquisition. That's another point. Mergers and acquisition. Upon merging, companies may need to restructure. When a company buys or acquires another one, that may necessitate restructuring. Companies often restructure after a merger or acquisition in order to integrate operations, to streamline processes, and eliminate redundancies. And that can lead to cost savings, increased market share, that can lead to improved efficiency, and so on. Mergers and acquisition. There is also mention on reducing costs, improving efficiency, and so on. So we can say improvement of efficiency. To improve efficiency. Or let me use a more general term. Let me call it operational management. All right? Or operational improvement. Let me use a more operational improvement. Operational improvement. This has to do with eliminating wastages, eliminating inefficiencies, and so on. Restructuring can be a way to improve operational efficiency and productivity. And that may involve consolidating functions. That may involve outsourcing non-core areas or activities. It may also involve implementing new technologies. Operational efficiency or operational improvement may involve introducing new technologies. Do you understand? That is a reason for corporate restructuring. Then there's someone who mentioned something to do with changes. Changes, what was it? Regulatory changes. Regulatory changes. Regulatory changes. Changes in laws, changes in regulations can necessitate corporate restructuring, and companies may need to reorganize in order to comply with new, say, environmental laws, new labor laws, new tax regulations, and so on. Regulatory changes. There's a point some of you did not mention. I didn't see it. It's called succession planning. Succession. Don't forget succession planning again. Don't forget it. Now, this happens when there is leadership changes. Changes in leadership of a company. Okay, when there are major changes of key executives, when the main personnel, the key executives retire, companies may restructure to ensure smooth transition and to position the company for future growth. You understand? So you have financial distress, mergers and acquisitions, operational improvement, regulatory changes, succession planning. These are 5 points. Okay. Then we may also have what we call shareholder what? Shareholder, let me call it activism. shareholder activism. Shareholder activism. This is just pressure from shareholders which can trigger corporate restructuring. We may have activist shareholders or activist investors who may push for changes in the company's strategy. Do you understand? Company strategy. And that brings to my mind another reason which I need to note down very fast before I forget. And that should happen to you when you're in an exam room. When you are writing a point, you can see I'm thinking about shareholder activism. Okay? In an exam room, when a point comes to mind, write it down very fast. You may have read candidates. This has happened to me many times when doing exams. You may have read through question 1, question 2, question 3, question 4, all the questions, and you have summarized the points. Maybe you have to give 7 in question 1, then you roughly gave 6. You forgot the 7th point. Then 1 hour later, when you're answering question 7, the 7th point may pop up in your mind. So what you do, you note it down immediately. The same thing that has just happened to me right now. I had forgotten strategic alignment. Okay? In listing, I had forgotten here strategic alignment. As I was explaining shareholder activism, strategic alignment came to mind because I mentioned the word strategy. As I was saying that there are some activist shareholders who may push for changes in the company's strategy. Okay, when I said strategy, then I remembered strategic alignment. So, to continue explaining this point, these shareholders may also push changes in capital structure. They may want some changes to be made in the capital structure of the company. Or the shareholders may want changes to be made at the management team level. You understand? So that can necessitate corporate restructuring. So how many reasons are there now? We have financial distress, mergers and acquisitions, operational improvement, regulatory changes, succession planning, shareholder activism, and strategic alignment. 7 reasons. Part C reads, outline the procedure for removal of company director from office. Procedure for removal of a company director from office. Who's going to go first? It's your chance to attempt. Nadra says notice is given to the director. Bernard says application to the registrar. Maureen says notice of resolution to remove a director should be given. Angela says notice to director with reason for removal. Perry says special notice served to the company. Claudia says special notice should be served to the company holders and to the directors. Moses says director has the right to make representation, defend himself. Maureen says the representation to be read at the meeting. The representation to be read at the meeting. Paris refines her answer and says special notice served to the company. 1. Number 2, notice of removal, representation, convene a meeting, vote, let the dude go home. All right. or stay. K says an ordinary resolution is to be passed to remove the director. Good. So it has to begin with notice. Notice. So you are right, candidates. Notice. And what is this notice? It is notice of the intention to remove the director. Notice of intention. Notice of intention to remove the director. But you cannot just stop at that, candidates. Who issues such a notice? Who is eligible to give a notice to remove a director? You have to state. Don't just say notice. Where should this notice originate from? Talk to me. Before you go to ordinary resolutions, let's deal with the notice. It is notice of intention to remove the director. Bernard says shareholders. Moses says members of the company who are shareholders. That is true. Shareholders. Shareholders. That is to say that a shareholder, so I've put an S here in bracket, or a group of shareholders. It can be a single shareholder or a group of shareholders who holds at least 10% of the voting rights. Holding at least 10% of voting rights. It's not just anyone who can give notice of removal of at least 10% of the voting rights. Such a person can give a special notice to the company of the intention to propose a resolution to remove a director at the next general meeting. Candidates, procedure. You are discussing the procedure. It is not like some of you are stating that a notice will be given, then a meeting will be called, then a director will be removed. No, there has to be notice of intention to remove, and not anyone can just give this notice. It has to emanate from a shareholder or a group of shareholders holding at least 10% of voting rights. Such can give a special notice to the company of their intention to propose. So they are just proposing to have a resolution to remove a director at the next general meeting. So is it only the shareholders who can do that, give a notice? I had asked a question, who gives this notice of intention to remove? You've said shareholders, which is true. Can anyone else or any other group of people issue this notice? Bernard says debenture holders. Debenture holders. Debenture holders. Bernard, you are allowed to guess. This is the right time to guess, but don't guess in the exam room. Make sure you have the facts. Debenture holders. Can debenture holders propose? Debenture holders who are not owners, can they remove a director of whom they didn't appoint? Come on, somebody. Company secretary. Claudette, a company secretary is just an agent. A company secretary is an employee. Is an employee of the company. Keep guessing. I'm waiting for the final guess. I know it may be right. Someone may guess right, please. Court of competent. Court. The court, Bernard, is it Bernard? Court is an arbiter. A court only resolves disputes. But here we are talking about management of a company. We are discussing management of company affairs. Courts only come in to act as arbitrators. Board of directors. Board of directors. Board of directors. Board of directors. The board can also propose a resolution to remove a director. However, they must give the director in question special notice of the resolution and the reasons for it. You understand? The reasons. Then in the procedure candidates, we have the director's right. This is number one. Director's right to be heard. And this director may be heard in person, or the director may be heard through a representative. You understand? The director proposed for removal has the right to make written representations to the company and to be heard at the general meeting, either in person or through a representative. So before that happens, the director can write his response in writing. He has a right to be heard. It's not a must. It's a right which he can exercise or not. So he may come over to the general meeting and make oral presentations to defend himself or say whatever he wants to say in that meeting. General meeting. General meeting. Procedure. You see how it is flowing, candidates? Procedure. There is a notice of intention. The director has a right to be heard through written representations or to come to the meeting. General meeting. The resolution to remove the director must be passed by an ordinary resolution at the general meeting. Okay? Ordinary resolution at the general meeting. You understand? After the company receives the notice of intention from the shareholders or board of directors, and after the director has been granted his right to be heard or to make his written representation, then a general meeting is called where an ordinary resolution is passed. The resolution to remove the person through the resolution that is to remove the director must be passed by an ordinary resolution at the general meeting. That is to mean just simple majority of the votes. Simple majority of votes cast by shareholders who are entitled to vote. Then after the resolution, there is notification that has to be made to the registrar. The registrar has to be notified. Notification to the registrar of companies. The company must notify the registrar of companies of the director's removal within 14 days of the resolution. The resolution to remove the director. It has to be within 14 days. Procedure, candidates, procedure. So when answering, you have to remember the timelines. Notification to the registrar of the intention to remove the director after a resolution is passed, a simple majority of the votes at the general meeting. Notification to the registrar. You understand? But of course, there could be additional things that have to be considered in removing a director, one of which is in relation to the articles of association. The articles of association may contain additional provisions or requirements relating to the removal of the director. You understand? Apart from the procedure we've outlined, when removing a director, it's important to check if there are any provisions relating to additional requirements relating to the removal of a director from office. You understand? Other matters to consider will be employment contract. If the director has an employment contract with the company, then the terms of the contract will have to be considered. Then, of course, there is the issue of compensation. The director may be entitled to compensation or even damages if their removal is in breach of their contract or in breach of the Companies Act. So generally, candidates, that's the procedure for removal of a company director. 7 marks.